Right, that counsel for the claimant is contending that the handbook is a photocopy. Why?
It is not, my lord.
Yes.
Yes, my lord. There is no physical copy of the handbook. It's in electronic format, and it was simply printed in black and white.
Come again.
My lord, I'm stating that there is no physical copy of the employee handbook.
Okay, there is no hard copy.
Yes, hard copy of the employee handbook. It's a soft copy which was printed in black and white. The same thing in front.
Soft copy that was printed to the present document.
Yes, my lord.
Yes. This is in respect of the handbook.
Yes, my lord.
He said he has no quarrel with the children of the second one, the evidence of payment of salaries, other things.
Yes,
But
my
he
lord.
is complaining that the printout document, the computer generated one, which has not been in tandem with the provisions of the Evidence Act, particularly Section 84.
My
What's
lord,
your reaction to that?
in response to that, I would humbly refer my lord to Section 12(1) of the National Industrial Court Act.
Corresponds to the contention
Yes, my lord.
of the claimant's counsel about document number 3 on the list of documents.
Yes, my lord.
I humbly refer this court
I humbly refer to Section 12(1),
to section
12(1)
section 12(1)
B
B
of the National Industrial Court Act, my lord,
of the National Industrial Court Act.
which permits this court, my
Which
lord,
year? Which year is that?
2006, my lord,
2006.
which permits this honorable court to depart from the rules of the Evidence Act in the interest of justice.
That's all.
And my lord, I'll also be relying on that with respect to the employee handbook, which I've stated is an electronic copy which was printed into physical copy. I would also be relying on Section 12(1) B of the National Court of Industrial Court Act, my lord. My lord, and if I may just end that I raised the same objection to counsel's documents during his trial, and the Honorable Court, in its gracious wisdom, invoked the provisions of Section 12(1) of the National Court of Industrial Act. And I permitted, and I withdrew my objection to his.
You are now holding a position that what is good for the Gonda is also good for
Very
the
well, my lord. Very well, my lord.
But did you satisfy the circumstance? The circumstance of what you call in the interest of justice.
My lord, in the interest of justice, my witness is joining these proceedings via Zoom. My witness, from the facts of this case, is far away from Nigeria. So it would be burdensome on my part to procure documents, my lord, from the witness. It will cost extra cost on our part to do that.
The council is contending, is saying that this document,
yes, my lord,
particularly the third one,
yes, my lord,
if you are not saying that the first one is not a photocopy, if you are saying so,
yes, my lord,
in your reply, he is still contending that the third one, being a printout,
yes, my lord,
out the requirements of 84 of the Evidence Act. He
yes,
said that there is supposed to be a certificate of compliance.
Yes, my lord.
You understand? Along to be tendered alongside with this document, that this is the procedure that is followed in terms of preparing the document.
Very well, my lord. The certificate of compliance, my lord, would have to be signed by the witness.
Yes.
And witness is far away from us, my lord.
Is it in all cases that it has to be signed by him?
Because he's the one who has produced the documents, my
lord.
lord.
You read section 84 of the Evidence
Section
Act
84 says that.
in
very well, my lord. It says
from subsection 1 to subsection up to 4. Did you read it properly?
Very well, my lord.
Yes.
And with specific reference to the certificate, it says that it should be signed by the person in whose custody that document was. The document was not in our custody, my lord.
Okay, you are saying it's not in our custody.
It's not. It was not in our custody. It was in the custody of the witness prior
okay,
to
I have
when.
heard you. I have heard you. Let me hear. Do you have anything to say in respect of the response that was made before me about your objection?
I have also said, but in our own case, it was a different scenario. It was written to raise an objection as to the note wanted to get an urgent conversation. But in this instance, my lord,
Mm-hmm.
in this instance, my lord, the objection I've raised is basically to the type of evidence they brought.
To the type of evidence being tendered.
Being tendered, my lord, it is right.
Yes.
That if an original is not available, what is expected is that the foundation should be laid and the photocopy becomes admissible. Again, as regards the screenshot, the link between document is such a tender. The witness needs not sign the certificate of compliance. The law states anybody that is in use of that computer, it could have been an office clerk, it could have been a lawyer. That is my reply.
I'm sorry to interfere, but
do you want to speak as an amicus curiae?
yes, my lord.
You want to speak as an amicus curiae? What's
My name is Olubenga Omolaja.
Olubenga
Olubenga Omolaja.
Olaja?
Onolaja.
Onolaja.
L-A-J, my lord. My lord, as an amicus, I don't know the facts of their case. I just listen to the submission of counsel. I just want to point my lord to the recent amendment in the Evidence Act in 2023. My lord, I'm not speaking to the facts of the case, but I know that amendment dealt with the issue of certificate of identification.
By that amendment,
Yes, my lord,
the issue of certification
was dealt with. In fact, that amendment, that amended act was amending section 84 of the Evidence Act 2011.
The 2023
Yes, ma'am.
amended
In 2011. It covers the issue of computer-generated evidence being admissible as any other type of primary.
He said it covers the areas of what?
Evidence that are admissible under section 84.
Evidence that are admissible.
Yes.
Under section 84.
Of the 2011 Act.
Yes.
I'm not speaking to the facts of the case because I don't know what actually.
Say the law and the pronouncement, and if possible, if there is any pronouncement.
It inserts in the Principal Act information in electronic form, where any law provides that information or any other matter shall be in writing, on type, written, or printed form. Then, notwithstanding anything contained in such requirement shall begin to have been satisfied if such information or matter is rendered or made available in electronic form and accessible so as to be usable for subsequent reference. Record in a computer to be admissible. Notwithstanding anything contained in this act, any information contained in electronic record, which is printed on a paper, stored, recorded, or copied in optical or magnetic media, or cloud computing or database produced by a computer shall be deemed to also be a document if the conditions mentioned in this section are satisfied in relation to the information and computer in question, and shall be admissible in any proceedings without any further proof or production of the original as evidence or any content of the original or any fact stated in it or which direct evidence will be admissible. It also deals with authentication of electronic record. It says that subject to the provision of this section, any person may authenticate an electronic record by affixing digital signature.
Yes.
So this amendment even goes beyond and speaks to the fact that a person can actually affix and a digital signature on any document, and it will be admissible in court. Like I said, my lord, I'm not an amicus. I just thought that should be pointed out to my lord in terms of admissibility of what learning counsel is trying to admit. I would rather advise. I can't even advise. My lord, I'm just stating the facts, and I think all I've read is on the internet. It's not what I fabricated, and it's also a fact that is public notes is that the amendment, the evidence that was amended in 2023 was signed by President Buhari. I think around January.
Yes.
So we've gone beyond the issue of certificate of authentication. I've found several matters. I don't need to put this again. All I don't need to do is to plead the fact that this evidence was generated by this computer on this date. The computer was used in a general course of what we used to use it for, and all of those things which we used to put in the certificate of authentication.
Yes, that is it. You can see that even now, even with this amendment, the 2023 version of the Evidence Act, which has amended the 2011 Evidence Act, it is still going around again and giving you some conditions. These conditions are that it has to be satisfied, the condition must be satisfied. The conditions include the fact that you have to set the background, the circumstances, how you are able to get the document, isn't it?
Like I said, I'm not.
Certainly.
I don't even know what
yes.
stated in the opinion.
Yes.
But I just read one other counsel.
But counsel, do you have any pronouncement of any superior court with regards to the version you are referring this court to?
I might probably have to look. But I know that because it was, I think it was around January 2023 that this amendment was done.
Yes, yes,
I am
it is.
certain that in several other matters that we have found, I don't think any counsel has ever objected to the fact that you don't put this at full authentication in support of documents that
if you read critically very well. Yes. Yes.
All I was just trying to say is you have said it all, my lord. The court has said it all. It is always better to comply with even this new amendment by stating the conditions under which that the computer generated evidence was generated, which is to state that it was obtained on this date. I used my computer, HP something to generate it. It was used in the other course of what we used to use it for, which are the things that you have said in your what is it called, your certificate of authentication. What is new act was just because I wrote an article about it. That's why I'm a bit naive to stand up to say it.
Yes,
I don't answer this question in respect of the case.
Thank you very much.
Like I said, I'm just an amicus. I don't know both parties. I don't know what they have found. I'm just
no. Your duty as a counsel is to assist the court in, in bringing the law as it is to the court. That's why you are not bothered with any fact of the matter. That's one is all within your reach. You don't have any business with the fact of the case. Your duty there is to assist the court. What is the position of the law as it relates to so and so? That is your duty, and it's the duty of every counsel, because that's why they are all ministers in the temple of justice, and that is it. So thank you very much. Are you still on the? You are still coming in again?
I just want to say something.
No, you don't need to join issues with him. You don't need to do that.
I'm going to say.
Yes, thank you. Yes. I've gone for a right to my ruling. I can listen to you anyway. Let me listen to you.
I am thinking in section 59. Section 59. And we're talking specifically with respect to AI.
Section 89.
The new act of 2011 against that.
2011.
Yes. And
Section 89, what is it?
of element tax.
Yes. In particular, sub, is it sub 1 or sub 8? AI. Yes.
Original exchange or appears to be in possession of power. I of the person against whom the document is sought to be
Proved.
proved. So, my lord, sir, if my lord is certain that the original document that is so challenged is in possession of the other party, who are the privilege, to read the front load and name from the onset that the original will be required by the court and choose not to come to the court. The court is bound. The court is bound to agree whatsoever other secondary document that is provided for the court, even without bringing in without laying any foundation. No, sir, that is the law, and that is more on part of it.
Okay.
And
Thank you very much. This is all what we have. Um, what is before me at the moment is an objection raised on the admissibility of two of the documents which the learned counsel for the defendant sought to be admitted in evidence. The grounds stated by the claimant's counsel for his objection against the admissibility of these documents mainly are that the handbook is a photocopy, whereas the witness through whom the documents sought to be tendered did not state the whereabouts of the original. That is to say that there is no foundation laid in law for the tendering of the said documents. In respect of the printout of LinkedIn profile, counsel for the claimant contended that the document on the face of it is a computer-generated one where there has not been compliance with Section 8.4 of the Evidence Act. He urged the court not to admit the two documents while raised no objection as to the evidence while there is no objection as to the admissibility of the payment of salary being tendered. In response, the defense counsel submitted that the handbook is not a photocopy, but that the handbook has always been a soft copy, and that same was printed out in the hard copy, thereby making same not photocopy but original. Moreover, counsel urged the court to invoke the provisions of Section 12, sub 1B of the NIC Act 2006 and overrule the objection and admit the two documents in the interest of justice in evidence. As an amicus curiae, this court is privileged to have listened to submissions of two other gentlemen who, though not in the matter, but drew the attention of this honorable court to the provisions contained under the 2023 amended copy of the Evidence Act, and also Section 89 of the Evidence Act 2011. I have meticulously listened to submissions made by all counsel in this matter. However, what I feel very important at this trial is for the court to be seen to be doing justice to both parties from the onset up to the conclusion. I am set to do that. In doing this, I read through the provisions of Section 8.4 of the Section 8.4 and 8.9 of the Evidence Act 2011, which deal with computer-generated evidence and tendering of documents in evidence where ordinarily the original is in the custody of the other party. I read with keen interest the provisions of Section 12, subsection 2B of the NIC Act 2006, which is the act that establishes this honorable court before the Third Alteration Act of 2010, culminating into coming into being of Section 254C of the 1999 Constitution. Section 12, subsection 2B of the NIC Act 2006 is the provision that relaxes this court from strict application of Evidence Act. In essence, this court can relax the evidential requirement of Section 8.4 of the Evidence Act 2011 when computer-generated documents are in issue. This court has, in a number of similar matter, admitted documents, but reserving their probative value for consideration in terms of the merit of the case. A good instance I can recall is the case of Dorothy Adaze Aogu against TFG Real Estate Limited, unreported, suit number NICN/LS/262/2013. Judgment delivered on the 4th of June 2018. So also Davison OOB against Access Bank PLC, unreported, suit number NICN/LS/406/2013, judgment in which was delivered on the 16th of July 2018. It is in view of these decisions, basically decided on the strength of the provisions of Section 12 of the NIC Act 2016, that as it is now, I discountenance the objection raised and admit the documents in evidence, and they are accordingly marked as Exhibit D1 to D3, respectively. The evidential or probative value will be determined in terms of the merit of the case at the judgment stage. This is my ruling. Yes. Yes, is the witness still with us?
Yes, my lord, the witness is still with us.
Yes, counsel. Is that all?
Yes, my lord, that's all for
Any cross-examination?
Yes, my lord.
You can go ahead.
Mr. Rob, can you hear me?
Yeah, if you could go a little bit closer to the microphone, that would be appreciated. Thank you.
Witness. Can you hear me? Can you hear me?
Yes, I can hear you, my lord.
Okay. Now, the other counsel is going to ask you some questions in form of cross-examination.
Yes, my lord.
Yes, counsel, you can go ahead. The witness is with us.
Mr. Rob.
Yes, counsel. Are you able to unmute your screen? That might be the best way to hear, because I'm hearing through the judges, I think, at the
Counsel,
moment.
do we time you?
My lord, I won't.
We have some other matters, and you have seen that we are pasted on the witness box there, 20 minutes for cross-examination, except otherwise. Except otherwise, I said. But we are giving you 20 minutes as you have indicated there. Unless if it is otherwise, maybe we can see into the reason why we can add more minutes for you.
Okay, my lord. Yeah, Mr. Rob.
Yes, counsel.
Yes. You took part in the recruitment process of the claimant.
What's your reaction? Witness.
Sorry, I didn't realize that was a question. Apologies. I did not actually myself take part in the recruitment process directly. I was not one of the interviewers. I was not one of the interviewers within the recruitment process.
Okay. He said he was not part of the interviewers. Yeah, Mr. Rob, are you aware of the terms of employment of the claimant?
Yes, I am.
Good. My lord, he said he's aware.
Yes.
Yes, Mr. Rob, you know Vivian Akibaho.
You know what?
Vivian Akibaho is part of names of members of staff of the defendant.
I do not recall Vivian.
Come again?
I do not recall the name that you just said.
Vivian Akibaho. I think it's an Ugandan name.
Vivian Nabisere?
Do you know the person? Do you know that name?
I don't know the name that you said, no.
Yes.
He doesn't know the name or he doesn't know the person. Which one?
You don't know the name or you don't know the person?
I think you are referring to a lady named Vivian who used to work for Safefoda in Uganda. Is that correct?
Yeah. Yes.
Yes, I'm aware of a Vivian who used to work in Uganda.
Okay, you are aware of that name, not that you know the person.
I know the person. I know the person called Vivian, but they do not go by the name that you just said.
Okay.
I want to be clear.
Okay. Okay.
Yes.
My Lord, for the next few minutes, I will be reading out some names.
Yes.
Yes. Yeah. Do you know Jacqueline Bugambi? Jacqueline Bagambi. Do you know that person?
How do you spell that name?
My Lord, it's
Jacqueline
spelled.
Bugambe.
Yes.
Chakun.
Jacqueline. My Lord, JACQUIL.
QUI.
Yes. LINE. Bagambi. BAGAMBE.
Mm-hmm.
Yes. Do you know that person?
I don't believe so.
He said he doesn't believe so.
I don't believe so. The name doesn't.
Yeah. I just touched the name. He said he doesn't know the person.
Yes.
Yes. Do you know Alistair Susok? Alistair Susok.
Lester. How do you spell that?
Yes.
ALASCAIR SUSSOCK.
XOCK.
Yes, my lord. You know that person, Mr. Rob?
Yes, I know Alistair Sussex.
Yes. Alistair Susok.
Yes.
Yes. Do you know Pamela Rinel as well?
Sorry, please could you repeat the surname?
Pamela Rinel.
Yes.
PAMELALA, then REYNELL.
Yes.
You know Pamela, Rob?
Yes.
Okay.
Yes.
You know Olaoluwa Arokoyu?
Ola.
Yes.
Are these names contained in the paragraphs of the?
Yes, they are in our process, but I want to, my Lord, I will let it go. I will just ask my question straight away
Okay.
to save time. I will refer to it in my address. So the names I've mentioned, you are aware they all took part in the recruitment of the claimant.
They were part of the recruitment team.
Yes. Do you confirm that, Mr. Rob?
I'm aware that some of them were part of the recruitment team. Yes. As I said, I don't know all of the names you mentioned. I'm not sure all of them even worked for SafeBoda.
Please come again. I'm not sure I heard you.
Well, I said I'm confident that, or I know that some of those names were involved in the recruitment process. I cannot confirm that all of them were. As I explained, there was one person whose name I didn't even recognize. So I cannot confirm that person whose name I didn't recognize was part of the recruitment process.
Yes. That will lead me to another question. My lord, sir, can I go on, sir? You know a company called Brighter Monday?
Called
Yes.
Bright Monday.
Brighter Monday, a recruitment company in Uganda.
He said yes.
He said yes.
Yes.
And you confirm that that company has worked for SafeBoda. That company has worked for the defendant, and that company actually recruited the claimant.
I'm aware that they have been employed by SafeBoda for hiring in specific roles. Yes.
He confirmed that, my lord.
Yes.
Yes, Mr. Rob. You confirm again that your company evaluates staff performances.
Do we have staff? Do we have performance reviews? Is that the
They
question?
evaluate staff performances. Staff performances. What do you say to that, Mr. Rob?
Yes.
He said yes, my lord.
Over time, yes, we have performance reviews.
Then tell the courts how you review performances. Is it by mail? Is it by query? Is it by just tell the court.
For the performance review process. But I think this will be done at different times, right? So your probationary review will be different to your.
I'm not asking you about probation, no.
6 months.
How do you evaluate performances? I'm not talking about probation or extra time. How do you review? Do you send queries? Do you send mails? How do you do it?
I don't know what you mean though by do you send queries or mails? Do you ask for other people's opinion? Is that what you're asking?
Tell the court how you evaluate performances. If you ask for that, just tell the court how you do it.
Me as a line manager.
How does he do that?
Okay.
Yeah, I don't know what he said.
So, in my role, I will answer as I have understood the question. In my role as a line manager, I will ask for 360 feedback from a number of other staff who have worked closely with that individual over a longer period of time. So I will complete that Uh, and then I will make an assessment based on a number of competencies and make an assessment.
You see, this must be a very long answer because the nature of the question you asked, he said he has to tell you
Based on
Yes.
provided
how does he do in terms of the evaluation performance of the staff.
Yes, yes.
And it's going to be so wide enough, for him to be narrating to you how we did. There are so the methodology,
My lord, I will leave that question. I will ask another question.
because some of the questions as you're asking them, they are very, very good to only maybe address.
I understand, my lord. I'm just trying to, based on the defense files, there are certain things I just want to but my lord, I understand the message of the court. I will keep it short, then so that we proceed. Yes, yes, and I'm satisfied with the answer. Mr. Rob, your company uses KPI as part of
Your company uses
key performance indicator, KPI,
yes.
to evaluate staff performances. Staff performances.
That is not strictly the current method, no.
No. Yes or no?
Well,
I understand.
so you're asking me about how I assess performance.
I'm
I
not
do
talking
not
about
use
you. Your company uses key performance indicators.
The company does not have a strict policy of using key performance indicators to judge every single member of staff. No.
He said it's not every time. Okay.
Yes, go ahead.
Yes. There was never a time the claimant was reprimanded, warned, or cautioned.
The claimant was
There was never a time the claimant was reprimanded, warned, or cautioned while still in the services of the defendant.
what's your reaction?
Sorry, again, apologies. I didn't realize that was a question for me. It sounded like a statement. I do not believe that the claimant was reprimanded at all during the probationary period that she worked.
Please come again, please.
I do not believe that the claimant was reprimanded.
He said he did not
I do not believe
that
the claimant was reprimanded at all during the 3 months during the probationary period.
Yes, counsel.
Hello. You are aware that it was a company that approached the claimant.
Not directly, no.
Has what? The company has what?
I asked him, he is aware that it is the defendant that approached the claimant. And he said, not directly, no, which is against what they stated in their statement of defense.
No, I want to be clear with this, maybe, counsel, is you just previously asked me about Brighter Monday, right? So Safe Border used Brighter Monday or other recruitment companies.
Mr. Rob, leave that. That is my
in order
it is my
to
job to
try.
develop whatever I've deduced from you. So leave that. There's no need going there.
Okay.
My lord, sir, I thought my lord is still right. You are aware that the claimant made the presentation before you employed her. A presentation
Sorry,
of,
that the claimant made a presentation.
yes, a presentation, like after being interviewed, she was made to prepare a presentation and presented same to the names I called earlier.
I'm aware that she was required to do a presentation as part of the interview process, yes. As stated,
Yes,
I don't
okay.
know, I cannot say for certain, under oath, exactly who she presented it to. I would be surprised if she presented to all of those people on the list, though.
So you agree with me? She went through a rigorous interview and process before your company employed her.
Yes.
He confirmed that, man.
Yes.
Yes. Witness, you know one Dora Hagai.
Yes.
Who is she to you, to the defendant?
She is a former employee.
A former employee. She held which position?
She worked within the HR team. I think she might have been a senior manager, but
She was
I'm
a
not
senior
100%
manager.
sure of her title at the time.
So you confirm she's a senior manager?
No. As I said,
So
I cannot recall her title at the time.
my lord, he said he cannot recall her title. At the time, yes. Of course, it's the same. So witness, who is Pamela Renel to you?
She is a former employee of Safe Border.
Another former employee of Safe Border. Can you please tell the court the title she was holding while, or the title she held while with the defendant?
Her title when she left Safe Border was Vice President of HR.
As the court pleases.
Council, we are taking as much as possible.
My lord, I just have one more question.
You go in excess of the time.
My lord, I just have one more question.
One more question?
One, just one.
Okay.
Mr. Rob, have you ever been to Ibadan?
Yes.
You've been to Ibadan?
Yes.
And you are aware that the claimant several times went to Ibadan?
I do not know how many times the claimant went to Ibadan. The claimant was there at least one time because I was there at the same time that the claimant was there.
Okay. That's all, my lord. We are grateful, sir.
Let me take this answer. What's his reaction to that question? He said, have you ever been to Ibadan? He said yes.
Yes.
And you aware that the claimant many a times goes to Ibadan. What's the answer there?
He said he's only sure of once, that the claimant went to Ibadan once, but he is not sure of others.
Yes. Any re-examination? So in that case, where are we? That's the case. Defendant's case is closed. And the witness is, the witness can step down.
Thank you, my lord.
Very well. So you agree as to the filing pattern of your written addresses. You have to agree on the filing of your written addresses. You have your 21 days. Minus 10 days. You take 11 days. You abridge the time. We're not willing to do that. Anyway, you have your 21 days. Consequent upon that, you have your 21 days as well.
And the complete.
Yes. Then you want to make use of your 7 days. So now, let's look at it. 49 days from starting from tomorrow, we see. When will it end up? So that within the period, you'll be able to conclude all your filings. And then when you conclude, when you finish the filings, we'll be able to tell you when you are coming back for the adoption.
Complete.
Step 14 July 12.
Oh, yeah, 6%. Not the point of positive matter.
as I said, defendant's case is closed. Council should explore the days for filing their final written addresses. It is in this regard that council should file and exchange their respective final written addresses before the 12th day of July 2025, consequent upon which a date will be communicated for adoption. Soft copy should also be exchanged and filed in court. For the next case,
Case number NICX/LA/275/2022. Mr. Richard Ayanwu against Baker and Orbis Company Limited. Mr. Richard, are you there?
Yes, I am. Please, can you confirm if I'm audible?
The claimant is present virtually or not.
this one is for what is it? Who is in court?
The president,